18 state AGs, attorneys general, now supporting Donald Trump against Judge Chutkan's gag order. This is at the D.C. Circuit Court of Appeals, and we got this filing from 18 states. Now, of course, Trump allegedly is an insurrectionist. They don't want him to speak about anything in this case because it might jeopardize the trial. Now, what about Trump's free speech rights? Doesn't he have the right as a political candidate to get out there and do politics and speak and communicate his ideas and his policies? One of which might be that the DOJ is broken and corrupt. But not only Trump, what about our rights to hear from him and the people in the states to be able to go and vote for him and to be able to hear his perspective on the corrupt DOJ being the victim of the corrupt DOJ? And so 18 state AGs say he needs to be able to speak about this so that our rights are not violated. We'll read through the filing. We'll also hear what Kinzinger and Christie has to say about this before wrapping up with Marjorie Taylor Greene and her take on what happens if Trump goes to jail. But we have 18 state AGs filing an amicus brief, which is a friend of the case brief, and it's coming in the Court of Appeals. And this is what the docket looks like there. Out of the DC Circuit, you're going to see a lot of activities. We've got the Christian Family Coalition out of Florida. They're also filing an amicus. We also have here America First Legal filed an amicus. We have this one is the one we'll look at. 18 states. The states are Iowa, West Virginia, Alabama, Alaska, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Nebraska, North Dakota, Oklahoma, South Carolina, South Dakota, Texas, and Utah. Now, we're missing Arizona here. We don't have Republican AG here, unfortunately. But other states are also missing, but 18 is a pretty good number. And this is what was sent in to the Court of Appeals for the D.C. Circuit challenging Judge Chutkan. And you can see it's a 23-pager, and something's looking a little bit strange with my red pen. So let's get this reef situated here. It is United States of America versus Donald Trump. Trump is appealing this to the D.C. Circuit Court out of the United States Court of Appeals. This is the brief for the Amici, the friends of the court, the various states that we just talked about. And what are they asking for? Supporting Trump and reversal. Supporting Trump against Chutkan. The table of contents telling us that Chutkan really did not narrowly tailor this and that this whole thing is unconstitutional. Let's see what the state AGs say. They tell us that the states of this country stand foursquare behind the protections of the First Amendment of the Constitution, saying no branch of the government may abridge the First Amendment. They tell us that this right is paramount when it comes to protected political speech. It's at the core of what we talk about in this country. The district court here, Judge Chutkan, overstepped its role in issuing an overly broad order denying Trump from making public statements about individuals involved in the judicial process. The court, through Judge Chutkan, imposed limited restrictions on extrajudicial statements that hinder and inhibit an ongoing presidential campaign, particularly as applied to President Trump's ability to make statements about witnesses who are themselves a part of the campaign. Now, that overbroad order, an order that a major United States presidential candidate must mute himself on a major campaign issue, cannot survive any level of scrutiny. And when we talk about the Constitution and constitutional violations, there are different standards of scrutiny that we look at. How closely, how magnified with a magnifying glass do we look down at this thing? If it is a law that is not violating your constitutional rights, we don't look at it that closely. We just say, if you have a problem with that, go vote about it. But it's not a constitutional violation, so we don't really pay much attention to it. But if it is a First Amendment right and you're a political candidate in the middle of a political campaign and they're saying, you can't talk about politics, we go, what? We got to take a very, very high-powered electron microscope and look at that thing and scrutinize it very, very in-depth. And if we do that to this gag order, it's not going to survive. We're going to look at it and say this thing's bad. So beyond its overbreadth, meaning it's just too overbroad, it is too over-encompassing, the order is impermissibly vague. It covers a bunch of conduct, and we don't even know what it's talking about. Now, by failing to articulate what it means to, quote, target the individuals that the order identifies, their prior restraint will unlawfully chill President Trump's speech. What does it mean to target? Can he comment on it, or is that a target? Now, the states, the Amici states, the friends, all the 18 of them, they are home to upcoming caucuses and primaries. Now, as administrators of free and fair elections, we have an interest in ensuring that no illegal prior restraint is entered against major political candidates. Indeed, our citizen and us, we have an interest in hearing from major political candidates in that election. This order threatens our state's interests by infringing Trump's free speech, and so accordingly, we are filing to defend him. And by the way, this should be every attorney general in the state, in the entire country signing on this thing. They say former President Trump is the Republican frontrunner for president. Even were he not, President Trump enjoys the First Amendment right to speak, and American citizens enjoy an essential right to hear what he has to say. President Trump is also currently the defendant in this underlying case. But that does not justify Judge Chutkan slapping President Trump with this prior restraint on his free speech. Courts, no doubt, they must ensure that they take steps to rule and regulate in a manner that will protect their processes inside the courtroom from outside interferences. We know that. But the record before Chutkan's court here, however, makes it doubtful that this court could justify any restraint, much less this one, which is both too vague and too broad. Both those deficiencies beg for this court's correction. First, while Chutkan correctly raised First Amendment concerns in its order, it misapplied the binding strict scrutiny standard, which is the highest level microscope, which does not justify issuing a prior restraint against Trump. This overly broad order cannot survive any tailoring analysis. So sometimes we'll say that we can pass a law as long as it's narrowly tailored so that it doesn't become overbroad and violate more rights than necessary. Second, they say Chutkan failed to meet the standards required to ensure its order was clear enough to avoid being impermissibly vague, telling us that courts do not presume that restrictions curtail constitutionally protected activity, that they do as little as possible, right? We don't just presume and give them the benefit of the doubt. They actually have to be narrowly tailored. And lastly, the presidential campaign is in full swing. Iowa's First in the Nation caucuses are 62 days away, 2 months from the filing of this brief. So the election interference is already happening right now, right? We're not going to wake up in November 24 and, if things don't go our way, say that the interference occurred on election night. Okay, they're doing it right now. Like, all of this is propaganda to say Trump's a criminal, Trump's a criminal, Trump's a criminal, Trump's been indicted, Trump's felony, blah, blah, blah. And if Trump can't defend himself, the harm is happening now, right? Every time Trump is gagged and he can't comment on these illegal prosecutions or these unjust prosecutions, that is him being harmed. That is the election being interfered with. It's happening right now. Just like we saw about this time in 2019 rather, we were seeing all of the election litigation be filed, right? All of the COVID rules were changed because of COVID. We need to move this deadline and collect ballots and do all these things. Happens well before. It's happening right now, right? And they're gagging Trump as part of that effort. So as Americans turn their attention to the upcoming presidential election, there should be special care taken to ensure that they can judge the candidates on their own merits. Entering a prior restraint that may limit a candidate's ability to campaign must meet the exacting standards. Now, this court did not narrowly tailor its prior restraint. The order prevents, quote, all interested parties, including the parties and their counsel, from making any public statements that might, quote, target the team, counsel, staff, or this is the most broad one, any reasonably foreseeable witness or the substance of their testimony. Like, what the heck does that even mean? It means whatever you want it to mean. And it means everything and nothing. So Trump can't say anything because of that problem potential. It purports to find that President Trump and his counsel, his lawyers, quote, pose a significant and immediate risk of prejudicing the process. Well, they would prejudice the process by exposing the process, which might prejudice your process, but not a just process. We want a just process. We don't want a corrupt process, which is what we're watching. So in doing so, the order fails to be the least restrictive means to further the government's ends, and thus it fails to satisfy the strict scrutiny standards. The court's analysis falls short and prohibits too much speech. The short order also elides the complexity of this issue and fails to justify itself, and so therefore should be reversed. They say that if you are going to be impinging upon the First Amendment, you have to do it with strict scrutiny. They say the party seeking the restrictive order has the heavy burden of demonstrating that without this restraint, that a fair trial will be denied. That heavy evidentiary burden must be met, but here they haven't met it. In other cases, we've seen how this works, and the Sixth Circuit too has also employed a clear and present danger test. Sixth Circuit recognizes the separation of power and other things, but here the order from Chutkan was imposed after the case against Trump had been pending for already 3 months. The government, Jack Smith, they introduced no evidence that any group protected by this order had actually ever experienced any threats. But the court found the government introduced, quote, undisputed testimony that when the defendant publicly attacks individuals, the individuals are threatened and harassed. And they say, okay, fair enough. But the court's abbreviated analysis did not connect Trump to the attacks. Trump might say something about somebody, and somebody else might threaten or harass that person, but not Trump. Unlike criminal defendants, in a standard case, there is a significant national attention and analysis that follow Trump's statements. And to justify a prior restraint, the court court must more thoroughly explain why Trump is causing the harassment here. There is no degree of certainty that Trump's prior restraint will work, and without any evidence, the government's order must fail strict scrutiny. And similarly, a prior restraint against, quote, any reasonably foreseeable witness or the substance of their testimony, it just goes too far. At least one potential witness is now campaigning for the Republican nomination against Trump. Other potential witnesses are speaking about President Trump's candidacy, and multiple candidates campaigning against him have invoked criminal charges against Trump, but under the district court's prior restraint, Trump cannot respond to him. That cannot be the narrowest, most narrowly tailored mechanism. They tell us more about the Sixth Circuit, and they say that this order is just too vague to satisfy the strict scrutiny standards. They explain, beyond the slipperiness of the target, the order is also having problems with his objects. It prohibits Trump from targeting potential witnesses, even a potential caucus opponent, by identifying him or calling for his voters to vote against him. But it's unclear who the universe is. Who are all these reasonably foreseeable witnesses? We can't tell. Now, the order's vagueness here restricts speech by inevitably leading Trump to steer far wider than he otherwise would, right? Trump just says nothing because you don't know. He doesn't want to get in trouble. What the order prohibits is so vague that it shades itself in contradiction. It simultaneously forbids Trump, for example, from making statements that target potential witnesses like Vice President Pence, and then explicitly says that Trump may criticize other people like Vice President Pence. So Trump must carefully parse every word and every mention when talking about Pence, but only the federal government and Pence know what his potential testimony is going to be, if he even is a witness. And so Trump has to be tap dancing around a minefield in order to figure out what he is allowed to say and not say. They say, for another example, the order also allows President Trump to criticize the government generally, including the DOJ. But how is that any different than targeting Jack Smith or the special counsel? And so fear of failure to comply with the order while also speaking on matters of political importance during a campaign is an almost axiomatic example of a court that can chill speech. The order's subjects cannot know what is fair criticism and what crosses into contempt. Is the line drawn at President Trump identifying members of the government generally by name or position? Is he prohibited from making statements about the weaknesses of the case against him because that targets special counsel or their testimony? Can he talk about how the accusations, without specifying the source, are wrong or fail to tell the whole story? Or can he comment on the testimony or a witness? Requiring someone to ask those questions and answer those questions whether the person's speech is chilled or not. Now, the order effectively prohibits Trump from discussing major campaign issues nearly 2 weeks before the Iowa caucuses, with Super Tuesday just 6 weeks after that, when this trial is going to start on that Monday. The citizens of our states have a right to hear from the candidates on important issues, including when one of those issues is an ongoing prosecution against that candidate. Now, many officials, they say, engage in a rough and tumble of politics. Already, there have been circumstances where overzealous federal government action has led to the stifling of state elected officials and their voices. The risk that follows upholding the order of future prior restraints issued against political candidates in other contexts is deeply unsettling. Political opponents and opportunistic litigators may seek to stymie debate by relying on the precedent set here, and this would be an unwelcome burden on the democratic process. They say elections, including primaries, are a prime opportunity for elected officials to hear from their constituents. The Fifth Circuit explained this as well. They said restricting official speech is crucial for the listening citizens. And a presidential election is a key component of our democratic republic. A prior restraint on any major party candidate in a primary, much less a general election candidate, stands just as likely to inhibit communication between constituents and officials. And Trump being restrained from discussing matters of importance with his potential constituents, that's us, and the states are being prohibited from learning about those conversations, are problematic as well. So given the magnitude and importance and effect of such overly broad and vague prior restraints on Trump's speech, this court should reverse. Respectfully submitted by the Attorney General of Iowa, Brenna Bird and Eric Wesson, and signed by a bunch of other state AGs. We've also got West Virginia, Alabama, Idaho's here, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Utah, Texas, South Dakota, Carolina, Oklahoma, North Dakota, and Nebraska, all here signing off on this one. And so it looks like we've got a bunch of AGs all signing off on this, and we'll see if any others join, but they are right. We have a right to hear from Trump and to hear what he has to say about all this stuff. Of course, he is in the middle of it. He's in the thick of it. He is the person who's being prosecuted by his political opponents. But some people do not want to hear from Trump. In fact, this is Kinzinger and this is Christie. We'll we'll hear from before we get to Marjorie, who are saying that Trump is the greatest threat. He needs to be stopped no matter what. His First Amendment rights be damned. We have to stop him because he is dangerous to the future of the world.
What do you assess the third party movement, if there is another candidate, knowing that these presidential elections are made state by state? What's your analysis?
I'm worried because, look, I love the idea of a third party. I love the idea of a centrist party. It has to start in the House of Representatives before it goes to the president. Now, here's the deal. I think Donald Trump's base of support is very firm. I don't think you're going to peel anybody off of Donald Trump into something else, right? There are people like me, that not me, but like me, that don't agree with everything Joe Biden does, but would vote for him as opposed to Trump. If you give them an out, you give them a Joe Manchin or somebody, they'll vote for that person. And you may be like, I would say this too, like, good, vote your conscience. But the problem is the consequences of a Donald Trump victory are so dire that I think you have to hold your nose and vote for somebody maybe you don't like, because we can survive 4 more years of Joe Biden. I'm not sure we can survive 4 years of Donald Trump.
Oh, man. So they're getting very nervous, and that is not a good position to be in. Like, you do not want your message to get out the vote to be just go hold your nose for our guy, right? Not really what you want there. Now, this is Chris Christie, and Chris Christie really needs Donald Trump to be convicted and removed, probably imprisoned if he's going to have any shot at winning. But that's their whole strategy now, right? Indict, convict, and remove.
The fact is, here's the problem, Sandra. This is all a play for second place if you don't go after Donald Trump. Yeah. And Nikki Haley said the other night, he's the right president for the right time. Well, I don't know that somebody who got indicted 4 times based upon their conduct in office turns out to have been the right president for the right time. And, you know, I look at the way they cuddle up to Donald Trump. Well, good, if you're content with second place, then don't take on the front runner. I've been taking on the front runner from the beginning because I want to win this race.
Totally disqualifying to say that any of Trump's indictments are legitimate reasons why he shouldn't be president, because they are illegitimate indictments, right? They're not actually anything that is based in reality or justice. It's all political, partisan nonsense. Chris Christie knows that, but he's just using this as tool to victory, okay? He's actually using his enemies, so-called, to take out his top opponent so that he can move into the top position. It's pretty reprehensible, but that's who we're talking about. Now, here's Marjorie Taylor Greene to close out this segment, explaining, we'll be voting for Trump from jail, baby.
And if he gets convicted of one of the myriad criminal offences he's been charged with, and if, I'm not saying when, if he is convicted and he gets a jail sentence, will he be president from a prison cell?
Absolutely. People are going to vote for him even if he is in jail. I would vote for him even if he's in jail because we have communism in our country.
That's right, peers. We're voting for him no matter what. You guys can indict him 34 more times. Nobody cares, okay? Because it is illegitimate. Nobody believes in your Justice Department anymore. And that's by your own doing. It's not anything Trump did. It's by you guys deciding to break 234 years of historical precedent, prosecute your political opponents 4 times, change laws in New York to create new civil actions with Miss Bergdorf, try to take away $250 million of his businesses, and so on. People are starting to get irritated about it. 18 state AGs are now jumping in on it. There will be more, no doubt, and we'll be here to continue to cover it, my friends. Thank you for joining us as we do. Don't forget to check out robertgovea.com if you want to access any of the mind map we just went through, or go download the PDFs that we just reviewed. It's all available, robertgovea.com. You can also sign up for the daily newsletter there so that these segments will be delivered to your inbox. That way you don't miss anything, and we'll be looking forward to seeing you right back here on the next one.